looking at the law, at some point you might be investigated, you might have a complaint. And if and when your day in court comes, you will have a series of defences that you will need to put up against that position. Obviously, the more evidence you have to back up your position, the better. You don't need evidence, but it certainly helps. And it seems to me that GDPR, if you boiled it down into a single phrase, it's about what's been reasonable. It's about what's been reasonable for a data subject, from a data subject's perspective. So what I'll be showing you over the next sort of 15 or 20 minutes is a series of slides about research we have done across this area. This first two bar charts, first one was done in 2017 and the next one was done in February 2017, next one was done in December 2017, so about 10, 11 months apart. And what we've done here is we've defined a category of data subject as data fundamentalists. And this is a definition that's quite widely used in the database marketing sphere. And they're defined as people who agree with the idea that consumers have lost their control or lost control of their data. They disagree to the answer that businesses handle their data properly, and they disagree that the law provides reasonable protection. And what you can see there, in just that 10, 11-month period, there's been quite an increase in this group of people. This is a look at, we work with lots and lots and lots of brands, and initially our remit was really to help them with consent. Subsequently, we sort of directed our research perspective into two other areas. One is around legitimate interest, what is reasonable from a risk-based perspective, and then also around privacy policies and ensuring that that is clear and understood from the data subject's perspective. A lot of brands have focused, in my experience, on being simply technically compliant. And what I mean by that is making sure that the way that consent is expressed is correct within the bounds of the law, but not in terms of perhaps compelling to a data subject. So when I was at the Telegraph 20 odd years ago, I used to run their database marketing program, collect millions of records, and we would hide the opt-out box. No one would find it. And if they ever did, what they'd find is a series of sort of legal terms in there, which were really there to cover the back of the publisher. That's completely different now. Now, consent is a matter of persuasion. So you have to be obvious, you have to be clear, you have to make it clear what you're committing to if you do agree to consent as opposed to not agree to consent. And of course, that means there's two sides to this. There's the technical bit, have you correctly defined the law and explain the processes, but there's also the persuasive bit. There's got to be something in it for them to agree to receive communication from you, to agree to have their data processed in a particular way. They also have to be reassured as well. So there needs to be an upside and there needs to be a reassurance factor as well. So getting back to this slide here, pre-GDPR, in the sort of Wild West days when there was a lot of basically opt-out going on and people were not aware they were consenting, typically data files were 60 to 80% of data subjects agreeing to consent, either by default or proactively. What I've seen is those organisations that focus just on getting the law right, that has collapsed to between 10 and 30%. There are exceptions. But those organisations that have sort of engaged marketing as well as lawyers, and have come up with way of presenting that language in a compelling and engaging way, have seen dramatic increases, not as good as it was before, but perhaps these people are more aware of what they've committed to. So they understand they're entered into a relationship, a dialogue with this brand, knowingly, but persuasively.